Well, now I would like to begin my report on OECD tax model with a summary on the Article 4, which concerns the residence. Well, the first paragraph says, for the purposes of this convention, the term resident of a contracting state means any person who, under the laws of that state, is liable to tax therein by reason of his domicile, residence, place of management, or any other criterion of a similar nature, and also includes that state and any political subdivision or local authority thereof, as well as a recognized pension fund of the state. This term, however, does not include any person who is liable to tax in that state in respect only of income from sources in that state or capital situated therein. So, Article 4 is intended to define the meaning of the term resident of a contracting state and to solve cases of double residence or to solve cases where double taxation arises as a consequence of taxation in the state of residence and in the state of source or situs. Paragraph 1 provides a definition of the expression resident of a contracting state for the purposes of the convention, and the definition refers to the concept of residence adopted in the domestic laws. Paragraph 1 refers to persons who are liable to tax in a contracting state under its laws by reason of various criteria. In many states, a person is considered liable to comprehensive taxation even if the contracting state does not in fact impose tax. For example, charities and other organizations may be exempted from tax, but they are exempted only if they meet all of the requirements for exemption specified in the tax laws. Thus, they are subject to the tax laws of a contracting state. Furthermore, if they do not meet the standards specified, they are also required to pay tax. In some states, however, these entities are not considered liable to tax if they are exempt from tax under domestic tax laws. So, the states may not regard such entities as residents for purposes of a convention unless these entities are expressly covered by the convention. Another example, where a state disregards a partnership for tax purposes and treats it as fiscally transparent, taxing the partners on their share of the partnership income. The partnership itself is not liable to tax and may not, therefore, be considered to be a resident of that state. In that case, how I explained previously, paragraph 2 of Article 1 clarifies that the convention will apply to the partnership's income to the extent that the income is treated for purposes of taxation by that state as the income of a partner who is a resident of that state. However, Remember that paragraph 2 was introduced in Article 1 only in the Model Tax Convention last update in 2017. As criteria for the taxation as a resident, in paragraph 1, the definition mentioned domicile, residence, place of management, or any other criterion of a similar nature. These are various forms of personal attachment to estates which, in the domestic taxation laws, form the basis of a comprehensive taxation. Full liability to tax. Paragraph 2 relates to the case where, under the provision of paragraph 1, an individual is a resident of both contracting states. To solve this conflict between the laws of the two states, special rules must be established which give the attachment to one state a preference over the attachment to the other state. As far as possible, the preference criterion must be of such a nature that there can be no question, but that the person concerned will satisfy it in one state only, and at the same time, it must reflect such an attachment that is felt to be natural, that the right to tax devolves upon that particular state. The relevant facts to which the special rules we apply are those existing during the period when the residence of the taxpayer affects tax liability, which may be less than an entire taxable period. Note, in Italy, tax year coincides with civil calendar year. In UK, tax year runs from the 6th April to the following 5th April. A simple example. In one calendar year, an individual is a resident of state A under the state's tax laws from the 1st January to the 31st March, then moves to state B. Because this individual resides in state B for more than 183 days, the individual is treated by the tax laws of state B as a state B resident for the entire year. Applying the special rules to the period 1st January to 31st March, the individual was a resident of state A. Therefore, both state A and state B should treat the individual as a state A resident for that period and as a state B resident from the 1st April to the 31st December. A little curiosity, this solution is not possible in respect to Spain due to the fact that according to its internal law, the fiscal year coincides with the calendar year and there is no possibility of concluding the fiscal period by reason of the taxpayer's change of residence. In this case, a mutual agreement procedure will be needed to ascertain the date from which the taxpayer will be deemed to be a resident of one of the contracting states. The first special rule says that gives preference to the contracting states in which the individual has, owns or possesses a permanent home available to him. That is to say, the individual must have arranged and retain it for his permanent use. This means that the individual has arranged to have the dwelling available to him at all time continuously for the purpose of a stay, as opposed to staying at a particular place under such condition that is evident that the stay is intending to be of short duration. As regards the concept of home, it should be observed that any form of home may be taken into account, just a rented furnished room, for example. But the permanence of the home is essential. Another example, if a house is owned by an individual, but it has been rented out and effectively handed over to an unrelated party, the individual no longer has the possession of the house and the possibility to stay there. So, this house cannot be considered to be available to that individual during this period. It should not be considered a permanent home, and it cannot be useful to solve the conflict between the law of the two contracting states. This criterion under subparagraph A will frequently be sufficient to solve the conflict, i.e., where the individual has a permanent home in one contracting state and has only made a stay of some length in the other contracting state. The second special rule of the second paragraph. If the individual has a permanent home in both contracting states, or the case where the individual has a permanent home available to him in neither contracting state, i.e., a person going from one hotel to another, paragraph 2 gives preference to the state with which the personal and economic relation of the individual are closer. This being understood as the center of vital interest. Regard will be had to his family and social relations, his occupations, his political, cultural, or other activities, his place of business, the place from which he administers his property, etc. These circumstances must be examined as a whole with a case-by-case examination. The third special rule. In the cases where the residence cannot be determined by referring to second special rule, paragraph 2 provides as subsidiary criteria the habitual abode in one of the two states. It is a notion that refers to the frequency, duration, and regularity of stays that are part of the settled routine of an individual's life and are therefore more than transient. So, in case of doubt as to where the individual has his center of vital interest, tips the balance towards the state where he stays more frequently during a given period. For this purpose, regard must be had to stays made by the individual not only at the permanent home in the state in question, but also at any other place in the same state. The test will not be satisfied by simply determining in which of the two contracting states the individual has spent more days during that period. Note, subparagraph B does not specify over what length of time the determination of whether an individual has an habitual abode in one or both states must be made. The first example, an individual owns a house in both states A and B over a period of 3 years. relevant facts do not allow the determination of the state in which the individual center of vital interest is situated. The individual works in state A, where he habitually lives, but he returns to state B 2 days a month and once a year for a 3-week holiday. In this case, the individual will have an habitual abode in state A, but not in state B. The second example, an individual owns a house in both states A and B over a period of 3 years. Relevant facts do not allow the determination of the state in which the individual's center of vital interest is situated. Individuals work short periods of time in state A, where he returns 12 times a year for stays of 2 weeks each time, but he is present in state B the rest of the time. In this case, the individual will have an habitual abode in both state A and in state B. Note, the relevant period for purposes of the determination of whether an individual has an habitual abode in one or both states will not always correspond to the period of dual residence, especially where the period of dual residence is very short. The third example, an individual is a resident of state A and he moves to state B to work at a different location for a period of 190 days. So he considers a resident of both states A and B under their respective domestic tax laws. This individual lived in state A for many years before moving to state B, and he remains in state B for the entire period of his employment there, and he returns to state A to live permanently at the end of the 190-day period. During the period of his employment in state B, this individual does not have a permanent home available to him in either state A or state B. In this case, the determination of whether the individual has an habitual abode in one or both states would appropriately consider a period of time longer than the 190-day period of dual residence in order to ascertain the frequency, duration, and regularity of stays that were part of the settled routine of the individual's life. The fourth special rule, the following subsidiary criteria is nationality. When an individual has an habitual abode in 2 states, which would be the case if the individual is customarily or usually present in each state during the relevant period, regardless of the fact that he has spent more days in one state than in the other. The fifth and residual rule is if the individual is a national of both states or of neither of them, the question shall be solved by mutual agreement between the states concerned according to the procedure laid down in Article 25. Paragraph 3 concerns companies and other bodies of persons, irrespective of whether they are or not legal persons. It may be rare in practice for a company to be subject to tax as a resident in more than one state. But it is possible if, for instance, one state attaches importance to the registration and the other states to the place of effective management. Preference is given to a rule based on the place of the effective management, which is intended to be based on the place where the company is actually managed. So the issue of dual residence of entities other than individuals is to deal with such situation on a case-by-case basis, resolving by mutual agreement. Because it was considered that it would not be an adequate solution to attach importance to a purely formal criterion like registration. What are relevant factors that competent authorities have to take account to determine the place of effective management? For example, the place where the meetings of the person's boards of directors or equivalent body are usually held. The place where the chief executive officer and other senior executives usually carry on their activities. The place where the senior day-to-day management of the person is carried on. The place where the person headquarters are located. The place where companies' accounting records are kept. Which countries' laws govern the legal status of the person? Whether determining that the legal person is a resident of one of the contracting states, but not of the other for the purpose of the convention, would carry the risk of an improper use of the provision of the convention. The last sentence of paragraph 3 provides that in the absence of a determination by the competent authorities, the dual resident person, company, or other body of person shall not be entitled to any relief or exemption under the convention, except to the extent and in such manner as may be agreed upon the competent authorities. However, this will not prevent the taxpayer from being considered a resident of each contracting state for purposes other than granting treaty reliefs or exemption to that person. For example, if the person is a company, it will be considered to be a resident of each state for the purposes of the application of Article 10 to dividends that he will pay. I think it's enough for this part of my report.